Okay, hello everybody. Good morning, good afternoon, depending on where you're tuning in from today. I'm really delighted to be here and just spend a bit of time this afternoon talking with two true data protection experts with really a deep understanding of the tech regulatory landscape really across Africa, and whose work I admire both personally and professionally. So I'm joined by Mercy Kingori. Mercy is Policy Manager for Africa at FPF. She is based in Nairobi, Kenya. Mercy really leads our thought leadership and really thoughtful legal and policy analysis on the ground. And we are also joined by Ridwan Oloyede, who is AI governance and tech policy lead at Hive Advisory, based in Kigali, Rwanda. And Ridwan and Tech Hive have really been an excellent partner on the ground for collaboration, knowledge sharing, and true experts in the region. So thank you both so much for joining this conversation. Thank you to the audience who is tuning in now. Just to note that we'll also take questions, mostly towards the end, but please feel free to add them in the chat as we go through. So why are we here this afternoon? Essentially, what we want to talk about is that globally, we're in a moment in which we've seen that there is really momentum for legal reforms to data protection frameworks. We've seen, for example, in the EU, many of you know, we have the Digital Omnibus proposal that seeks to amend and make some changes to the GDPR, among others, or the AI Omnibus that's aiming to amend the AI Act. We know, for example, that the UK reformed its own data protection framework just last year with the Data Use and Access Act. And for example, in other parts of the world, South Korea is similarly exploring reforms to its data protection law to facilitate the development of AI in the country. And so similarly, across several African jurisdictions, we've seen a desire and a kind of momentum to reform data protection frameworks. But I think it's safe to say that in some ways this looks quite different compared to other regions, and is really driven by some of the local realities and contexts. So Mercy, you recently, you published an excellent analysis exactly on this topic, covering 7 African jurisdictions. For those of you who haven't had the chance to read it yet, do check it out in the comments. So Mercy, which jurisdictions are you looking at in this research, and what are you seeing as some of the main drivers of data protection legal reforms across?
Thank you so much, Bianca. And we, as you mentioned, we recently released a blog that looked at data protection reforms across several African countries. Those are just a few. And I know, I believe Ridwan will talk about a few more. But in our analysis, we looked at 7 countries. We looked at Nigeria, we looked at Kenya, we looked at Angola. We also looked at Mauritius. We also looked at Botswana and Seychelles. And across all these 7 countries, one of the things that clearly comes out, that's leading to some of these reforms that we're currently seeing, is at technological developments, and they look different in each of these 7 countries. So, for example, if you look at a country like Nigeria, where we looked at the 2 proposals that have been made so far, one of the things that you notice, at least for a country like Nigeria, the reforms revolve around creating very specific obligations for specific controllers, data controllers, I mean. So, for example, the first reform that we talked about, you see, they're trying to require social media companies to establish physical offices for some of these companies. In the second proposal, one of the things that comes out clearly is an attempt to provide or stipulate, probably in the amended law, specific obligations for developers, right? And also strong enforcement powers for the NDPC. In countries like Kenya, one of the things that is driving the reforms is, if you recall, a really public case around WorldCoin, where the question of sensitive personal data came out very strongly. And there was a parliamentary committee that came up with findings. Among the findings was several proposals for reforms within the Data Protection Act. In countries like Angola, and I know Ridwan might delve a bit more into this, we're seeing various changes. That have been proposed. Among them, very robust AI proposal laws, in addition to the current AI legal framework in the country. In Seychelles, so Seychelles is among one of the African countries that had early data protection laws. In the early 2000s. And the need to keep up with technological changes, broader obligations for controllers and processors spurred these reforms, at least in Seychelles. In a country like Mauritius, one of the things that we keep on seeing, because Mauritius has amended its data protection law twice, and each of these times that it has amended its data protection law has been, to keep up with well-known international best practices, which the country regards as important for its economic benefit. So I'd say generally what we are seeing as the main drivers are technological changes that are being seen across the continent, and lawmakers coming to realize that we need broader laws that cover aspects that were probably previously not covered in the earlier laws.
Thank you, Mercy, for already giving us a really interesting insight on really how the technological changes in the different countries are driving some of these changes, and also the way that regulators are responding to these challenges, and how lawmakers are responding to the challenges. And Ridwan, I would come to you, because while most reforms seem sort of largely driven with the national levels, there is also a role for regional bodies in reforms of the different frameworks. So what is your sense of developments, both perhaps at continental level and at regional levels?
Yeah, thank you, Bianca. We're seeing a lot of effort at the regional level, sub-regional level. Of course, primarily if you look at the African Union level, there's currently an ongoing effort to, for example, do like a significant modification to the Malabo Convention. There are ongoing conversation around that. And next to that is what you've seen with the Digital Trade Protocol, where now we have the annexures to the protocol, and it contains things like emerging technologies protocol. There's a whole annexure around emerging technologies. There's a whole annexure around data protection. There's one around cross-border data transfers. So you're seeing that signaling from at that level at the African Union itself. Then when you cascade down a bit into sub-regional bodies, in West Africa, ECOWAS is looking at amending its supplementary acts, and it has, essentially looking to modernize the 2010 act to make it more modern, but also to respond to emerging regulatory needs in the region, primarily, things like cross-border data transfers and finding a solution to that problem. Then if you look at the EAC as well, there's been a whole conversation around the data governance framework, but also there's a whole conversation around finding a framework to also address things around data transfer. There's a whole conversation happening at the SADC level as well. So if you look at that conversation, you're beginning to see it's gaining traction first, mostly at the African Union level, but also at the sub-regional level. Another interesting thing to pay attention to is what bodies like Smart Africa are doing. Last year, they published a model framework for things like data policies. There's also ongoing work to do something similar for, even things like addressing emerging technologies and stuff like that. So again, we're seeing that significant shift from, just leaving things to be to now trying to respond to make sure those frameworks stay abreast with the trends that are prevailing, but most importantly, to also respond to the regulatory needs of some of this at the national level, but also at the sub-regional and at the continental level as well.
Very interesting. Thanks, Ridwan. And just a follow-up question: do you find that, the sub-regional or continental frameworks or reforms, do you find that there are the different principles that emerge in these areas and feed into negotiations at national levels, or is it is this a way to kind of find alignment across different countries in the regions?
So, I mean, if you look at the last decade, the conversation on the continent has been how to, there's been a lot of conversation around harmonization. So, whether it's harmonization having uniform laws or whether it's harmonization having similar outcomes, that's a different conversation. But there's been, even at the NADPA level, NADPA is the Association of National Data Protection Authorities. At some point, like 5 years ago, they had a working group on harmonization for data protection frameworks on the continent. So you're seeing how primarily the conversation is really meant to have some sort of coherence where, I mean, again, whether it's similar outcomes, whether it's similar frameworks, there's that conversation happening. And it's geared towards, having some sort of an harmonized framework where, we can solve niggling problems like cross-border data transfers. We can solve problems. And because we're also seeing things like cross-border enforcement happening on the continent. So we can have framework that are modern enough, they can address those emerging challenges like I mentioned. But also, if you look at it historically, in the last decade, for example, you see the Malabo Convention, that's the African Union Cybersecurity and Data Protection Convention. So it was designed in such a way that it's meant to set like a baseline for a law should look like. But what you saw was that framework was been around since 2014, but never gained enough traction to be ratified until 2023. But what has happened since then is so many countries have actually enacted laws that were way advanced than what you had in 2014. And that's why there's also ongoing work to bring that framework, modern enough to also be able to be forward-looking enough to address some of the emerging challenges that we're seeing. So I guess the summary is, yes, some of these conversations are also playing a role in the national conversations, especially for more recent laws. And there are also a lot of draft laws on the continent. At least there are like not less than 6 to 7 of them currently that we're hoping, if not all, some of them will probably end up being a law by the end of this year. So you're seeing them play a role, but you're also seeing national level conversation driven by national priorities as well. So yeah.
Mm-hmm, absolutely, and I think this overarching umbrella of harmonization is always really important context to keep in mind. I'd love to dive into maybe one of the specific countries in this analysis. Mercy, for example, in Ghana, a new data protection bill was introduced in October last year, 2025, which I think includes some interesting notions around automated decision making, for example. But I think what also stands out is an approach to data ownership. Can you talk a little bit more about how the framework is developing in Ghana and about this concept in particular?
Yeah, so I think Ghana is one of the countries that decided to do like an overhaul of its entire data protection law as opposed to amending sections of its 2012 law. And as you rightly mentioned, certain provisions do stand out, right? And before going into the AI provisions and data ownership provisions, I think one of the gaps that the Ghanaian data protection bill seeks to address, which has for the longest time been a concern, is the issue of data transfers. The previous 2012 law did not have provisions on data transfers, but the new one, the 2025 law, contains robust provisions on this topic. With regards to automated decision making processes, section 46, I think it's section 46 of the 25 law, does introduce, as you mentioned, interesting provisions on automated decision making. And in this case, what turns out is that it does allow data subjects to proactively reach out to data controllers and ask them to notify them in the event they ever process their personal data through automated means, which is of course a slight deviation from common data protection laws in the continent, which assume data controller responsibility, but it does not ignore that that the data controller has an obligation to also notify. it only just introduces this unique aspect that other data subjects, you can proactively, without any reason, without any cost, reach out to a data controller and ask them to notify you if they're processing your personal data using any automated processes. And I think, as I mentioned, most African data protection laws mimic Section Article 22 of the GDPR, which does not, envision this proactive approach. So I think Ghana in this regard does stand out. With regards to data ownership, also again, Ghana's, I believe, Section 65 of the Data Protection Bill does envision data ownership rights. And maybe just to also mention, data ownership is not unique to Ghana. It's also, you can also find it in Uganda's Data Protection Act. And of course, there's been questions around, when we speak of data ownership, how would that look in practical terms? I don't think, when you're speaking of data ownership, we're speaking of, full-blown ownership of rights where we're trading personal data like commodity, like data subjects, can trade their data like commodity. I think it speaks strongly, when you're trying to interpret this provision, especially in light of, ongoing discussions in the context of most African countries. It assumes it's trying to, give data subjects more control, more agency, and especially with regards to their data subject to the data subject rights. And I think we haven't seen any at least attempts at enforcing this data ownership rights yet. But I would tend to believe it's not something that we're thinking that data subjects could own their data and sell it out like some like a commodity. So I think with regards to Ghana's data protection bill, those are some of the two provisions that do really stick out.
Indeed, very interesting, Mercy. And depending on how negotiations go, I understood there was a period that was where the bill was open for public consultation, and we could expect perhaps already this year for the law to be finalized.
I agree. So something to watch out for, and see if there'll be any changes, that might be probably in the new bill or law.
Yeah, excellent. Thank you. Ridwan, I would come back to you and also dive now, sort of switch gears and move to a different country. So some of the proposed amendments that we've been seeing, for example, in Angola, are very much driven by AI technologies, the speed at which they are developing. What are you seeing as some of the Oh, I think we're getting just a little bit of microphone noise. Great, thank you. So some of the changes in the Angolan context are very much AI driven. What are some of the main characteristics of this draft law that you're seeing, and how does it sort of aim to regulate AI?
I mean, we're beginning to see interesting amount of, data protection laws being used as a handcuff for some way AI regulation, even if it's just domain specific. And like you mentioned, Angola presents an interesting example, an interesting model. And that's also because that law doesn't exist in isolation. Next to that law is also like an AI specific bill that's currently under conversation right now. That was published last year for public consultation. So what you're seeing is what Angola is trying to do is explain a go and come model where on one hand there's an AI specific law, but on the second hand there's also a data protection law modern enough to deal with AI risk. So significantly, some of the provisions you see from the proposed AI bill deals with specifying, for example, what are prohibited practices as far as data protection is concerned. So things like social scoring, anything capable of classifying individual based on the social behavior, essentially. Things like this, harmful things that are considered to be legitimate, these that are considered to cause discriminatory treatment to people are broadly under what they consider to be prohibited practices. Then for those, so you also had some provision around dealing with things like AI operators. in the context. So it basically imposes a couple of obligations on them, from ensuring security, preventing discrimination, to be able to disclose that people are actually interacting with AI. Another thing it did also is to sort of also expand the scope of data subject rights that are currently available. So, you need to, again, disclose that AI is in use, allowing for human participation in decision making. Stronger, it further reinforces standard provisions like automated decision making, right, as well. But also when it comes to things like predictions and AI decision making, people should also get an opportunity to be able to contest it. And again, just to make sure this is not just some suggestion, he also did was also to reinforce the enforcement bit to say, if you violate any provision of this proposed amendments, it's going to be considered to be a violation of, the old Data Protection Act. And of course, Angola has a history of imposing strong enforcement. So prior to Nigeria, smashing that record on the continent, for the longest time, Angola had like the highest enforcement tier, as far back as 3, 4, 5 years ago. So that's something that, we'll begin to pay attention to. And I think, just to mention real quick, outside of Angola is also another interesting thing happening is also in Tunisia. The proposed amendment in Tunisia also talks about, made specific reference also to, to deal with things like AI risk. So again, the need for an impact assessment, the need for high risk AI, the need for things like, again, automated decision making, which was something that wasn't initially addressed in the 2004 law. Stronger transparency around, also some of this disclosure around the use of AI. So what you're seeing is we're seeing modification of data protection laws, or proposed modification of data protection laws, to now specifically deal with AI risk, and essentially, just strengthen the domain. And that's also builds on the effort of data protection authorities on the continent, whether it's through guidelines, whether it's, we've seen moratorium, we've seen some level of enforcement, we've seen some level of public consultation in some countries trying to understand this technology itself. So it builds on what some of these authorities are doing. And this is something that we expect to see to continue in years to come.
Thank you, Ridwan. And I think, so it's safe to say, I think that there are kind of two different things sort of developing alongside each other, which is making AI-driven amendments to some of the data protection laws, and sometimes in some countries also having perhaps specific national AI strategies or AI principles. So hopefully there is kind of a level of also harmonization between them, right? Brilliant. I think overall, what's really emerging for me, particularly from the data protection perspective, is seeing how, the different countries are really leveraging the flexibility of existing data protection laws, whether it's to account for AI development or for trying to introduce stricter oversight of social media platforms, for example, or aiming to reduce harms associated with sensitive personal data processing. Mercy, you mentioned the WorldCoin case that was, sort of sent shockwaves, I think, across the continent, and maybe is leading to some reforms. Mercy, I would come back to you and ask, sort of looking a little bit towards the future, what are some of these changes signaling about the future of data protection in Africa? Where are the laws going? How are they developing?
Yeah, so I think that's like a very timely question, given the fact that one of the things that data protection authorities are largely, by and large, thinking about is, where does data protection, what sectors are affected by data protection, from an interdisciplinary point of state of affairs. And one of the things that we will possibly see, in terms of future reforms is introduction of amendment of entirely new laws trying to address, personal data use, not only in data protection laws. We're also probably going to see a lot of, as Ridwan earlier mentioned, is it harmonization from a practical perspective, or, from an outcomes perspective. And I think it's already in play. We're seeing, data protection authorities come together either in forms of different cooperating in different forms, either it's in enforcing their different laws, or in different capacities, either to train each other on how how they implement personal data protection within their borders. So we're going to see a lot of these corporations, and probably could inform a lot of reforms of data protection laws, even if it's within regional economic communities. So some of this, I think harmonization, the desire for harmonization, will definitely inform some of the reforms that we could see, and I think again also because there's a really repeated use of this term emerging technologies in a lot of privacy and data protection laws. There's possibly there'll be need in future to demystify how does personal data protection processing activities interface with what they determine as emerging technologies. So a growing definition of what this looks like. So I think for me, I think that's what I could say could inform future reforms that we could see.
That's very interesting. So perhaps a more kind of holistic view of personal data use across different sectors more broadly. Interesting that you mentioned also the role of data protection authorities and kind of regulatory cooperation that will become more and more important as the regulatory landscape evolves, and also as regulators are presented just with new technologies and with different challenges. That's brilliant. And I think Ridwan, I would come to you with a similar question. With all of this in mind, how do you see the broader kind of data governance landscape evolving? You have more of this AI-driven perspective that's a very specific use case. So how are you seeing the future, let's say over the next couple of years? I wouldn't say 5 years. I think that's too long term, just a couple of years.
Yeah, I mean, what we likely see is we're going to see the increased proliferation of more countries trying to introduce AI-specific laws. Currently, we have no less than 5 African countries who have already published or some way have like an AI proposed law. So we're going to see that wave, maybe push it up to we're going to see more countries doing that. What we're also going to see again is going to be, more on the strategy level, more national strategies, more policies, more frameworks. Well, increasingly, we're going to see a lot of more activities from the data protection authorities. Like I said, in the last decade, for example, we've seen, as far back as 2018, 2019, authority like Morocco placed a moratorium on the use of facial recognition technology. So you're going to see more DPAs playing an active role in, emerging technology regulation broadly. But also what you've seen with some of them in Nigeria, for example, in its implementation directive, rather than use AI to be technology specific, use emerging technologies, which means whether it's AI today, whether it's quantum computing tomorrow, these principles continues to apply. So we're going to see some of them also take that model where they focus on a technology neutral direction or model rather than to be into space, because of course the problem with having a technology specific framing. But generally, I think these are like some of the things that we would see. And maybe the last thing I'll say is in the next few years, 3, 4, 5, whatever it is, we're going to see more African countries also, introduce their data protection laws. Now we currently have no less than 45 of them. The projection is maybe before the end of the year, we probably get 50 or maybe before the end of next year. So, and with more laws, you're also seeing, more authorities being created. But what many of these laws are also asking, especially the AI-specific laws, is also creating an AI-specific authority. So whether it's going to be a clearinghouse model, whether you're going to have AI-specific authority, or we're going to see more governance, different models, of course, being floated or shared, whether it's going to be like some sort of horizontal framework, we're going to see more of this emerging, again, based on national realities across different African countries.
Absolutely. Very interesting, Ridwan. Thank you. And indeed, DPAs, and then soon we will have AI authorities. I think this also seems to be a little bit the landscape that's emerging globally, right? As different regions introduce specific AI laws, or at least AI principles. And I appreciate the comment that you made about the technology neutral model and the principles based model. That is very, very interesting and important going forward as we continue to figure out how to respond to new technological challenges. So thank you so much. This has been such an interesting conversation. Thank you, everybody in our audience, for joining. So nice to see so many of you tuning in. If you want to continue the conversation, please check out Mercy and Ridwan's work in the region. Reach out to us, keep engaging with our work. And thank you again, Mercy, Ridwan. And we look forward to talking to you soon. Bye. Thank you.